The next item on the agenda for the meeting is public comment. And I understand there is one person who wishes to make public comment. If you'd like to step up to the microphone. You've made public comment before me in the past, and so you understand it's limited to 3 minutes.
I do, sir.
Great.
Thank you. Thank you very much for letting me speak today. My name is Connie Schmidt. I am a resident of Warrenville. I'm also the chair of the River Prairie Group of Sierra Club. I am here as a concerned citizen and the chair of the Sierra Club in DuPage County. And we are concerned that healthy native habitats are dwindling. And as a result, many species are in remission as well. After researching our website, it has been difficult to find wording on the changes that are being proposed for keeping beehives in DuPage County. And while 4-H projects, which were mentioned on the site for educational enrichment, are valuable, we're concerned that that could lead to larger possibility of beekeeping, and that might be troublesome. The specific reason I'm here today is to raise that concern with increasing the availability of honeybees in unincorporated DuPage, because they are actually a threat to our native bee populations. Honeybees are an introduced species. They are a managed livestock. They are not endangered. They are tended for and cared for by their owners. The current zoning you have is appropriate with larger tracts of land. It recognizes bees as a farm animal like a chicken. However, unlike chickens, the 300,000 worker bees per hive leave their enclosure. They forage widely, and they are capable of actually foraging 2 miles from the hive, which creates a 12-mile forage zone. They are gathering food on public and private land. The Diversity Society is the largest association that studies. In fact, they have stated that one study calculated that over a period of 3 months, a single hive collects as much pollen as could support 100,000 native solitary bees. Recent research shows that native bee populations are declining due to the loss of their available food, in addition to disease. And we know that honeybees are known for the spread of diseases and parasites. The rusty patch bumblebee is an example of a listed bee that's endangered, and others are under consideration for that listing as well. Native bees are effective crop pollinators. For example, bumblebees can buzz pollinate and honeybees cannot. So bumblebees are what's needed for your tomatoes, your eggplant, peppers, things like that. Native bees are effective, our largest agricultural crops here in Illinois are soybeans and corn. And those are not populated by insects. They're pollinated by insects. They're pollinated by wind. So beehives, so you know, they are not allowed on forest preserve property. Forest Preserve is very concerned about our native bee populations. The one exception to that comment is that at Klein Creek Farm, there is an educational group of hives for the public to learn about the farming that's done with beehives. I'm not against, and we are not against honeybees, but they need to be on a larger tract of land where the landowner can grow native species to support both populations, their introduced species as well as the native species. We hope you'll keep your current zoning as it is. Condensing it and allowing it to be on smaller properties could be a danger to our native bee populations, which are already dwindling. Thank you. Hope I did go.
Okay, no, it's fine. Thank you very much. Okay, do we have any other public comment?
I'd like to comment on her presentation.
Yes, step right up.
Okay, I'm Keith Meiser. I'm a longtime beekeeper since 1972. I'm a member of Cook DuPage Beekeepers Association. I grew up in Downers Grove. Don't live there now, but I had many beehives there. Some of the premises that were discussed here are just wrong. Beekeepers are very concerned about native bees, about all flying and pollinating insects. And we take our bees to places to educate people. Talk about that. She pointed out that bees fly a long ways, so effectively, unless you can cut a 5 mile circle out of your habitat. That's the only way you can keep honeybees out, and they live in trees all by themselves. They are no threat to native bees. In fact, they're protective. When there are honeybees in the area, when there's hives, people can't spray. They have to take many precautions that they don't if there's only native bees around. The number one, by many orders of magnitude, threat to native insects, native pollinators, is loss of habitat by far. And what she didn't mention is that other than bumblebees, there are thousands of species of native bees, most of which only pollinate a single species of flower. And if you wipe that flower out by loss of habitat, they're gone too, and they will never come back. Honeybees mostly gather nectar from plants that produce a lot of nectar, mostly from weeds and things along roadsides. These are not the plants that rely on native bees. And I might also point out that we're not native either. So, I'll rest my case. Thank you.
Okay. Thank you very much. Just want to point out for the record that no public comment whatsoever made during the open meetings required public comment section is part of the hearing record for any case, including tonight's text amendment. However, we've discussed this with the board in the past, and in order to be, it seems to me to be appropriately fair to those who missed some nicety of when to make their public comment and at which point during the hearing to make their public comment, we may, if we so choose, take notice of any public comment, just as we can take notice of the fact that today is D-Day. You might get that. So, having said that, I'm now going to go to next item on the agenda, which is approval of the minutes. We have several minutes, all of which have been circulated previously. First is the April recommendation meeting. The next is 24014, All for His Glory, meeting held April 11. The next is 069 Medina Road's Residences, meeting held April 16. The next is well, it's a typo, I think, but it's 27 West 121 80th Street Investments, meeting held April 18th. And that is C24017. The next is 24022 Somerset Plaza, meeting held April 25, 2024. And finally, the May recommendation meeting held May 2nd, 2024. Can I take a, if there's discussion or need to consider any of those items independently, I'll do that, but may I request a motion to approve all of those minutes? I move to approve as presented. Motion by Mr. Ketter, seconded by Ms. Anderson. Is there any discussion on any of those items? All right, no discussion being offered. Let's take a all in favor of the motion to approve those minutes, please signify by saying aye. Aye. Any opposed? The motion carries. That takes us to our recommendation cases for this evening. We have A through E. First is zoning petition 069, the Medina Roads Residences of Bloomingdale Township case. I would ask someone to make a motion.
I make a motion on this to deny. It was remanded. Well, it was a great presentation on remanding against the original presentation. I saw no reason to change my opinion. I think it's just not, I don't think it fits into there. It's not harmonious with the surrounding. Uh, lately, living order and workforce housing has come up repeatedly. Went back, reread living order. I don't think it applies here because there are some, I don't think, what do they call it? Exceptions. I think that would take it out of that. And then the last one is, part of this project is based on workforce housing. And there is no bona fide workforce housing ordinance in DuPage yet, so I am hesitant to make any type of finding that would bind the county. So for those reasons, I would, vote no on the
Motion to deny by Mr. Ketter. Is there a second to that motion? I'm sorry, I didn't hear who seconded. Is that Mr. Murphy? Yes. Seconded then by Mr. Murphy. Any discussion on the motion? I'll have to pass the microphone if there's no discussion on the motion. Well, generally, I'll just say that I didn't find anything compelling about the case in order to reconsider my view as expressed at the first hearing, and I would adopt those comments. There were not material changes which in the presentation, which would have changed my opinion. I don't know why it was remanded to us, but we did our duty and held a follow-up hearing. So let's take a roll call vote on the motion to deny, please.
Member Cutter,
Aye.
member Murphy. Member Moran,
Aye.
member Schultz,
Aye.
member Anderson. No. Member Vermont.
Aye.
Chairman Carthel.
Aye. The motion passes by a vote of 6 in favor and 1 opposed, so it's 6 to deny. That takes us then to the Cermak Builders case. This is a Naperville Township case. It is a conditional use for the duplex to remain in the subject property. Motion offered by someone from the area.
Hit the microphone, I can't see who's talking.
It's
Sorry.
Mr. Schultz made a motion to approve. Is there a second?
Second.
Ms. Anderson makes a second to the motion to approve. Discussion on the motion.
I'd like to be like this on the basis of it. My concern is it seemed like the owners came in originally, they were very cavalier. This way, we should get this. Then there was a presentation, then a re-presentation as they went down the list to find something. But for compelling reasons, maybe if it hurts them, I could be swayed. Yeah, my other problem with this is they're a business, LLC. They went into this as a business. They bought this property to make money, and they didn't do due diligence. And it does not fall into a conditional use. It's a variance, and I don't even know if I vote for the variance, but a conditional use doesn't go. But I'm amenable to hearing some type of argument to maybe afford them some type of.
Just as a point of clarification, it was originally brought as a variance and then restyled as a conditional use, as I recall. It clearly now is before us as a conditional use for a planned development.
Yeah, when we were looking at it before, I know that there was some questions and all specific legal things, which is probably beyond my ken, but I do think that they met the standards for conditional use in terms of, when you're looking at it, they're not changing the building itself, so there's not affecting light or air to the community. It's not going to significantly change the traffic. When you go down those lists, it looks like it fits. The fact that it had been a duplex for most of its existence, I'm not sure about every moment, but certainly most of it, and there's ample evidence that it had been used as a duplex for the majority of the time. I think, in my looking at it, that it seems appropriate that it, having satisfied the different conditional use standards, that I would approve it.
I think this is an abomination. It came before us as a conditional use, but there was no use cited in the ordinance that it could have been a conditional use too. So it was restyled as a conditional use for a planned development. At the hearing, the attorney was unable to describe how is this a planned development. To legitimize the mistake made by these investors, it is wrong. And if we do it and it is challenged in court, it will set a terrible precedent, which will affect other cases. Having said that, there is some appetite, I understand, to have this approved. And so I think it should be, I think we should establish, if we approve it, some conditions. Because number one, it's my understanding that the county board will soon consider text amendments which would authorize a case like this in this zoning district or similar zoning district. So if it's to be authorized, we should put some conditions on it. I think the condition should include a 3-year deadline, 3-year condition period, which we often impose, so that that 3 years would give time for the county to consider the text amendments. Next, I think we should have a, I think the relief, if granted, should expire if the property is sold to a new investor. Next, or if it is discontinued as a duplex, because this property has gone back and forth from duplex to single family over its history. And yes, a long time ago, it was legal and it existed as a duplex as a pre-existing non-conforming use. And then finally, I think so that an investor who is a sophisticated investor and does check title and does things like get a zoning endorsement from the title company, which most investors do, they will, if we record this relief, it will appear in the record for anybody who does any research whatsoever in if the property is resold. So I would suggest to the maker of the motion and the second that these time limits and recording and my other item about discontinued uses of duplex or sale of the property be considered as additional conditions, but I've spoken my piece, so now I need to hear from the motion.
I'm agreeable to all those amendments, the conditional uses.
Okay. Then Ms. Anderson also agreed. Any other further comments? Then can we take?
Would you just highlight one thing too?
You can.
They kept arguing that it was either legal non-conforming or grandfather. Once that first sale took place, those ended. So I'd like to somehow put in the deed too, so there is no misunderstanding.
Well, now I'm confused about that. If it's recorded, how are we gonna?
You're putting in there.
What's gonna be recorded is the zoning relief that we grant.
What is that, a granting of a conditional use for 3 years?
Yeah, so that you see conditional use, 3 years and expires, et cetera, et cetera. So if you go to search the title, you'll find it. All right, what the county board does. Let's take a roll call on the motion to approve, subject to those various conditions.
Member Schultz?
Aye.
Member Anderson? Aye. Member Murphy?
Aye.
Member Moran?
Aye.
Member Ketter?
Nay.
Member Roman?
Aye.
Chairman Carthel?
Aye. The motion passes by a vote of 6 in favor and 1 opposed and will be recommended to County Development Committee according. Then, if I can find my agenda, we have zoning petition 2417, 27 West, 121 80th Street. That is the, conditional use for group quarters. Can I take a motion on that case?
I'll make that motion to approve.
Ms. Anderson moves to approve.
I'll second that.
Mr. Ketter, seconds the motion to approve. Is there a discussion on this motion?
I think they've proved up the basis for this additional request. I don't think we need to put another term limit on this. They proved themselves up on the first conditional use, and I think they've done it. And if any violations would come up, there are adequate remedies available to them, to the neighbors, to seek action. So I'd say grant it without any revisiting in 3 or 5 years.
And what about expiration if the property is sold? All of our standard conditional use expiration conditions, if the property is sold, the operation or if the facility is operated by different people than we've heard from with their expertise.
I think Anderson and I assumed those were the general ones and they would go on each time.
Yes, but you know what, for the neighbors, I want to approve the.
Hold on one second.
Sorry. I want to approve this development as is. I hear your point, but I think it's important to have the neighbors speak up if there are, and then this gives them, yes, they have many remedies, but this gives them a chance for us to know. We may not hear the others. So I have no problem keeping it as it is.
I don't understand that.
Yeah, just, I think Barry's going, he can go to the, the 3-year.
A year?
Just keep the same as it was. They gotta come back if they do stuff.
Well, okay. So,
Is that not right?
yeah, I understand what you're saying. Okay, I agree with Ms. Anderson. I think this is a fantastic operation. Very presented in a manner that's very expert. I do believe that for conditional uses, we should have time limits on the other items that are enumerated for expiration, like sale, etc. 3 years might be a little short, and I know they don't want to come back, but it's fair to the neighbors, as you point out. What number would you suggest as an?
The staff on that, but I would go to 5 years, from 3 to 5.
Right, that seems okay. Probably none of us will be on the board in 5 years. Okay, any other comments? So. Yeah. Yeah, but we have to add them. Yeah, okay. We do have some of those items included. So we now are imposing an additional condition of a 5-year limitation, which would be incorporated as a part of existing condition 2 in our staff report. So everybody understands it. Now, if there's no further discussion, may I take a roll call vote on the motion to approve subject to those various conditions?
Member Anderson? Aye. Member Ketter?
Aye.
Member Murphy?
Aye.
Member Moran?
Aye.
Member Schultz?
Aye.
Member Ramon?
Aye.
Chairman Carthon?
Aye. Motion passes by a vote of 7 in favor and none opposed. Thank you. And then, thanks. I don't know, I guess Somerset Plaza is next. I lost my agenda, but I've got the cheat sheet, so. The next item on the agenda is 022 Somerset Plaza LLC. It's a request for conditional use to allow auto sales with auto repair in a B1 local business district. Anybody want to make a motion on this case?
I present a motion to deny because the petitioner failed to provide.
Hold on one second.
I provide a motion to deny because the petitioner failed to provide a detailed plan on managing and maintaining the auto auto sales and repair operation without negatively impacting the broader community, businesses, and parking spaces they are around.
Moved by Mr. Lamont to deny, is there a
I
second?
would second it.
Seconded by Mr. Ketter.
I think they should be separated. No, it was a good presentation by the attorney, but it just didn't seem right to me. And that you're gonna bring cars in from auctions and they have to repair the engines and then sell them and then, but down the block, they have a lot. I think do the engine work there, what the lot is their sales area, and that's why I would be against it.
No further discussion. We'll take a roll call on the motion to deny.
Member Ramon? Member Cutter?
Aye.
Member Murphy? Member Moran?
Aye.
Member Schultz?
Aye.
Member Anderson? No. Chairman Cardwell?
Aye. The motion to deny passes by a vote of 6 in favor and 1 opposed. Pardon me? Ms. Anderson. Now, never mind. Text amendment, I guess. Next item on the agenda is consideration of T 124, the text amendment. So let's take a motion on the text amendment in order to open discussion.
I'll make that motion. Discussion.
Okay, to approve, motion by Ms. Anderson to approve. Second,
I'll second it, subject to discussion and some changes possible.
okay, second and additional use, second by Mr. Ketter. So let's,
It's just in 3 years.
yeah. So let's open discussion. How should we begin here? So much of it is straightforward, but what points does anyone want to make?
I think it's come up and we alluded to it. It's with the video gambling. Our text amendment is now saying it's for cafes. The municipalities are saying unless you have the equivalent of some type, be it a small restaurant, you shouldn't, they're not approving it. And they're not approving by just not giving a liquor license then, and then not helping with the state giving the gambling. So I think that could be tweaked unless there's maybe Paul has a rational basis that clears it up for me.
Before we hear from staff, let's exhaust the comments. All right, generally I have the same concern. I've had a couple of CHO cases where somebody wants to have video gaming. You know, I've got to, I know I can get 6 licenses, but I got to have a restaurant. Please describe your restaurant. I got an Evo cooler. My wife made some sandwiches. I wrapped them up, and if anybody wants them, I'll sell them to them. Done. I don't want a legitimate. I'd like to hear staff comments about how we can resolve that issue. Anybody else want to comment on this point? I know we're going to discuss fees. We'll probably discuss other parts of this, but let's hear from staff about this particular aspect of the text order.
So video gaming is licensed by the state of Illinois. One of the requirements to get a video gaming device license is that from the state is that you have to get a liquor license from your local community. And that liquor license has to be a license to pour liquor. There are several different types of liquor license the county has. One's package, those are your convenience stores. One is pour. The only pour license that is available in DuPage County is for a restaurant or a tavern. When you get a liquor license to pour for a restaurant or tavern, and you juxtapose that against the land use consideration in the zoning ordinance, the only land use where you can have that liquor license is in a restaurant or tavern. In the zoning ordinance, restaurants, there are 5 different types of restaurants. There are carry-out takeouts, and there are class A and B and C restaurants. Class B and C restaurants are the only restaurants where you can also have a pour liquor license. But in the zoning ordinance, the only place you can have a class B or C restaurant by right is in a B2 or industrial zoning district. They are not permitted in a B1 zoning district. You're allowed to have takeout and class A restaurants, which have no liquor license associated with them, as a right in a B1 and a B2 zoning district. In addition, there are parking regulations for takeout, class A, B, and C liquor restaurants. The parking requirements for class B and C, which again is where you can have liquor license to pour, have a requirement of 15 parking spaces or 20 parking spaces per 1,000 square feet of gross floor area of your restaurant facility. What we have found over time is that when someone wants a video gaming license, they are not interested in having a restaurant. But the only license that is available equates to a restaurant or tavern. So what we have found is the practical application of these licenses is that the county has issued both class A package licenses and class B liquor licenses to establishment without going through the zoning process in some instances. We have found that where those situations have occurred, where those situations have occurred, we have had no complaints, no issues with parking, no issues with the relationship of restaurants and taverns relative to the gaming activities that are going on in those facilities. And I say no issues, there are no policing issues, there are no liquor license violations, there are no zoning issues relative to, for instance, people calling and complaining about lack of parking, not enough spaces for parking. So practically, what we have found is that where we have had establishments that have had both class A and class B liquor licenses to sell packaged liquor and also to pour packaged liquor, there have been no actual instances where problems have been created. So in order to correct the county's liquor control codes and the county zoning codes relative to the ability to have video gaming in establishments, we believe that creating a standalone land use where you can have both a restaurant and video gaming devices in the same area without some of the other requirements that are associated with a typical restaurant is the acceptable way to go. And with establishing these cafe licenses, they would allow for a cafe to be a standalone video gaming cafe where you would have to serve food and you would have to get a liquor license to pour, but your parking requirements would be dramatically less than the parking requirements for a typical class B or C restaurant. And so that's why we're distinguishing between a video gaming cafe and the standard restaurant. And the main reason there, once again, is that parking for a restaurant would be 15 to 20 parking spaces per 1,000. For a video cafe, it would be 4 per 1,000. What we have found in some of the testimony that has been submitted at public hearings where video gaming facilities have come in and talked with the county is that these type of facilities don't need the typical 15 or 20 parking spaces per 1,000 because of the way they operate. There are metrics that have been submitted that show that they're consistent with the typical parking requirements for retail type establishments. And in the places where they would be allowed in the B1 and the B2 zoning districts in the county, they're typically in strip shopping centers where the type of activities that occur in those strip shopping centers occur at different times than the video gaming cafes would operate. We've seen testimony and evidence presented by folks that have done the due diligence on that. So the bottom line is this is not a way to get video gaming out from underneath still being able to serve food and serve liquor. It just puts them into a different category where some of the ancillary activities that are associated with them don't need, for instance, as much parking as a typical restaurant would have. And that's why we've separated the gaming cafes out from the restaurants.
Okay, thank you for the explanation. Seems to me that we would expect nothing other than the operator of a strip center to say, to give the testimony that you gave that says we don't need that much parking. It also seems to me, as Ms. Anderson said with respect to another issue earlier, there is great value in public hearings. So as to make this a matter of right avoids public hearing. Probably, in my view, a mistake. It also seems to me that this is a fait accompli, so I give up. I'm gonna vote with truth. Now, Mr. Ketter, do you want to?
Well, I do remember that. That was a good explanation.
But you have the microphone, please. Sorry.
I do remember it, and you did clarify it then, and it didn't sit with me. And you brought up one other thing at that too, where they were framing off areas in a like 7-Elevens, because they can't have video for under 21, and they were doing it, and they were getting some type of special license, not a foreign license, but is that the package license?
Where we have about 14 or 15 properties that are convenience stores that have packaged liquor license, Class A liquor licenses. They also have received Class B liquor licenses, not to be confused with the Class B restaurant license, but Class B liquor licenses to pour in the same facility. But in order to do that, they partitioned off a portion of their C-store with a glass enclosed area where it's restricted to people over 21 years of age. In theory, that's where you can pour and drink your alcohol. And that's where the gaming facilities are.
All right, does anyone want to address the question, the difference of opinion about these bees and what we're doing to amend the ordinance with respect to these honeybee hives? Yeah, Mr. Schultz.
I have some comments for this, but one thing, maybe Mr. Boston,
Could you?
you can't hear me?
No.
I'll speak up.
Thanks.
Right, so Mr. Haas, currently. I guess I didn't really grab this from when we met before on this, but currently, how many hives can somebody have if they're under the 4,000? Where here they're saying we're to do 2.
So in the ordinance right now, the keeping of livestock is not permitted on a residential zone property unless you are considered an agricultural use. You have to have 5 acres of land and the primary use is agricultural. Those are our farms. If you're less than 5 acres in size, you cannot have any agricultural activity on your property, including beekeeping, unless you are engaged in a 4-H project. If you're engaged in a 4-H project and your property is over an acre in size, 40,000 square feet, a builder's acre, then you can apply for and receive a 4-H project from the Illinois Cooperative Extension here in DuPage County. And you have to do that on an annual basis. You have to provide us with a site plan. And we have to certify that you are 4-H and you can have any type of agricultural activity on your property associated with 4-H, including beekeeping. This code would allow for beekeeping on properties that are less than 20,000 square feet. We're also requiring you to, and the state requires you to get an agricultural, there's some debate on what the term is, but let's just call it a certification from the State Department of, the State Ag Department that your bees are registered with the state. We're also requiring in this ordinance to get a 4-H certificate. And the rationale for all of that is these bees are really being treated as hobbies on the property, similar to what 4-H is on properties over 40,000 square feet. And we're also limiting the number of hives to no more than 2 on properties that are less than 40,000 square feet.
Okay, well, thanks. That answers pretty much my questions from the staff. The one thing I am concerned about the rusty patch bee and other native bees. I do think that it's good that we pay attention to that. And we have the forest preserves that actively pay attention. But I did look up I'm not sure I'm going to say Cersei's Society and spent researching some of their things and their comment about the number of hives for this. Well, they want to have hives 4 miles apart, which is a 2 mile, but when you make a circumference. So, but in that circle, at the center of that circle, their suggestion is no more than 20 hives. Now I'm thinking, I in that same space around my house, I spent some time looking. And I only know one beekeeper in that space, and he doesn't have 20 hives. So I guess what my point is I think I'm going to vote to approve this. But I think that it's good that we have all this registration, because if we do see an issue of specifically in an area, we can address it because we know where the honeybees are. And we can also, spot where we have native bees that are having trouble if they are. And that's kind of my thought, is that this gives us some safeguards so that we're not just plopping beehives everywhere and having drastic declines based on the activities through 4-H.
I've got to point something out. That's an important notation, because you are going to have to get a 4-H license or certification on an annual basis. So you will have to be doing this annually with at least the 4-H program.
Thank you.
I'm not ready to make a decision about this. I'm very concerned, and I don't want to make a mistake. I don't see any reason to rush this, and I think the bee issue should be carved out until the County Development Committee and County Board has an opportunity to evaluate the information that Mr. Schultz discussed, that we heard in public comment for both sides, et cetera. So my own view is this text amendment should proceed without the portion that's related to the beehives and 4-H, et cetera. But we'll get to that later. One of my other concerns about the text amendment is the fencing in the corner side yards. I've discussed this with staff. I'm satisfied. I'd like, and my concern is the line of sight question. It always seems appropriate to me to have a public hearing so you can determine that there's no impact on line of sight. However, after having discussed it with staff, I'm satisfied that it won't be a problem. I'd like Mr. Haas to explain generally the line of sight impact for this text amendment.
So on a zoning lot, you have front yards, you have rear yards, and you have side yards. When your property is at the intersection of 2 streets, one of those side yards is considered what's called a corner side yard. The rule that we're talking about here is that currently in the corner side yard, the fence can only be within the first 10 feet of the corner side yard, can only be within the first 10 feet can only be 4 feet tall and has to be 50% open. The proposed change would allow that fence now to go 3 inches from the property line, be 6 foot 6 inches tall, and be 100% closed. The concern historically why we had that code in place, keep it 10 feet away, is the line of sight of the potentially a house behind the corner side yard that might be a front yard, and the concern that people driving in and out of that driveway might be blocked by a fence that's closer to the property line. We've had this in place probably for about 10 years now, and we've had a lot of zoning requests where people come in and say there is no line of sight issue, and those zoning requests have been approved. The concern that Mr. Carthol is raising here is the line of sight relative to cars driving up and down that street that might be blocked by the fence. The way we feel that that concern is mitigated is that the only place that you were able to put this fence, if the law is changed, is in the corner side yard. You still have the front yard setback, which is 30 feet, and that's distinguished from the corner side yard. You might think that we're allowing the fence to go all the way up to the front property line where there is the intersection of the street. That's not gonna be allowed because that front yard goes across the entire width of the property from the interior property line all the way to the intersection of the streets. That fence will have to remain at 4 foot 6 inches tall and 50% open. So you won't have a 6 foot tall fence in that front yard. It'll only be in the corner side yard. In addition, where we have the intersection of two streets, we have an additional regulation that says that within what's called a line of sight triangle easement, that is essentially where the two lot lines come together. You take a point from the intersection of the two lines, come back 25 feet, draw two dots, connect those dots, and you create a triangle. Within that triangle, which is at the intersection of those two streets and the intersection of those property lines, the fence can't be higher than 3 feet tall. Not only can you not have a fence higher than 3 feet tall, you can't even have any vegetation in that line of sight easement. So I think the concern here was, are we gonna be allowing fences to be 6 feet tall up to that intersection of those two streets, intersection of the property lines? The answer is no. There'll still be 30 feet of essentially open area where people won't have their line of sight blocked when they're at the intersection.
Okay. So are there any other concerns about the text amendment general? Well, I think we've resolved all of our issues with the exception of my issue about to be or to include the text amendment as it relates to honeybees. My own view is we should carve it out and deal with it down the line. If there's no other appetite for that, I'll simply abstain from the vote on the full text amendment, but I'm not trying to control the crowd. Yeah, Mr. Schultz.
I agree with you, Bob. I don't see any urgency that we have to have it, right this moment, and, having them take a second look at it probably is not a bad thing. So carving it out makes sense.
Let me offer the amendment to approve. Janice.
We can carve that out.
All right, then
We have one question that was here. In my understanding, state of Illinois agriculture oversees this and sets the rules. 4-H has their own rules too. So we can have the most public discussion that's ever been had, but it's probably, we're not the proper one. They should go in front of the agriculture department and get them to change any regulations, correct?
Well, in theory, yes, but to answer your question is yes, to both of those questions that you have to get a certification from the state. And we are requiring a 4-H certification as well. The 4-H certification provides the educational aspect, whether you're a child or you're an adult. So that's the value of that. And it keeps it on an annual basis where this is being checked by someone who we don't have apiaries here in the county. We're not bee specialists. So we're saying get documentation from the specialist and submit that as part of your application to us. We think that that's good coverage. And if there's an issue at the state or there's an issue with 4-H, those certificates and those licenses won't be issued. And therefore, even though they may be in compliance with the county zoning regulations, they won't be in compliance with essentially the two affidavits they have to get from the state or from the 4-H.
Okay. We now have a motion that has been amended to approve all of the text amendments that are before us, with the exception of those portions which relate to the bee issue. We've had sufficient discussion on that. I'd like to call the roll on the motion to approve majority of the text amendment, absent the sections on bees. Did you call the roll on that motion?
Member Anderson. Aye. Member Cutter.
Aye.
Member Murphy.
Aye.
Member Moran.
Aye.
Member Schultz.
Aye.
Member Ramon.
Aye.
Chairman Clerk.
Aye. Motion cast by a vote of 7 in favor and none opposed. I'd now like to take a motion on the text amendment as it relates to the sections concerning beehives, honeybees. We can do a lot of things here. It can't be, but it seems to me that we should make no recommendation whatsoever. Because our issue, I don't want people to come back to me and try to persuade me what's right and what's wrong about these. I want the county staff, development committee to do that evaluation. If we defer this, it's simply gonna come back to us. If we take a motion for no recommendation, then the development committee can proceed as it sees fit. Make sense? Motion for no recommendation. Is there a second to that?
told you just coming back to us.
Who knows? I'm doing my best to move it along.
That's not
Sure. Motion for no recommendation by Ms. Anderson. Is there a second to that? I'll second it. Seconded by Mr. Moran. Is there discussion on the motion? I don't know if we've ever had such a motion, but I don't see any need to discuss it further. Would you call the roll on the motion for no recommendation and with the side comment that we hope the county board, county development committee will evaluate this carefully?
Member Anderson. Aye. Member Moran.
Aye.
Member Murphy. Member Ketter.
Aye.
Member Schultz.
Aye.
Member Roman.
Aye.
Chairman Frenchco.
Aye. We make no recommendation to the county development committee with respect to the issue and request that they consider it. That motion passes. Thank you. That's the last item on the agenda, so I think we're adjourned.